All right, this is Ricky,
And this is Brendan.
and you're listening to A Gentleman's Disagreement.
What I wouldn't give for the hope I used to find in a case of lion's head. Folks of different minds, because even though it did not share the pains we share, that American ideal, friends made over arguments in an early morning buzz. Need an early morning buzz.
All right, Brendan, it is Friday, October 20th. I just got back from California yesterday. Still trying to get my my bearings straight. So I think we'll just hop right into it. What do you got for us this week?
I got a real personal treat on my end, Ricky. So we have done in the past 2 years previews of the upcoming term of the Supreme Court. And this particular term just got started here in October, and we are going to do another one of those preview episodes highlighting 5 of the major cases in front of the court this term, and also looking at some of the major themes of this court. And to do that, we are tremendously fortunate to be joined by Professor Renee Landers, who is a professor at the Suffolk University School of Law in Boston. And she is one of my professors, and that's why I am so thrilled to have her join, because she was my constitutional law professor my 1L year. It was my favorite class that I took in law school. It was one of those you'd sit there for almost 2 hours, and I could sit here for 4 more. So like, it was just like, I loved having these conversations with her. And the fact that I get to continue to do this post-graduation, I feel very lucky that she's joining us. But in addition to my personal connection, she is a real expert in constitutional law, generally administrative law in particular, which we'll get into is going to be particularly relevant for this term of the court. And I think she's just going to be, because the court this term doesn't have some of these kind of major headline cases on guns or abortion or affirmative action, some of these cases might have fallen kind of beneath people's radars, but are still critically important. And I think Professor Landers is going to be able to provide us with some insight into these cases about why they're so important, why we should care so much, and also educate us. So she's a great teacher. And for myself and for the podcast, I'm really excited to have her on the program.
Yeah, I can't wait. I mean, for those listening at home, you can't see how big Brendan's smile is over here, but I think it's going to lend to a great discussion, and I'm looking forward to it.
I am very excited. All right. So before we bring her on, just a quick reminder, everyone, the podcast is brought to you by the hardworking craftsmen at Cannon Hill Woodworking. You know, they've been building handcrafted high-end custom tables and desks in Boston since 2018. That's Cannon with 2 N's. You can check them out on Instagram or visit them online at www.cannonhillwood.com. Ricky, one of the major cases this term has to do with boats, with fishermen. So my question for you today is, where do boats that carry wood go?
I don't know, Brendan.
They go to the arbor.
Ooh, that's good. That's good.
I like that one. All right, let's bring on Professor Landers. All right, we are now thrilled to welcome Professor Renee Landers onto the program. Professor Landers is a professor of law, the faculty director of the Health and Biomedical Law Concentration and the Masters of Science in Law Life Sciences program at Suffolk University Law School in Boston. She was the president of the Boston Bar Association in 2003-2004, where she was the first woman of color and the first law professor to serve in that role. Professor Landers has also worked in private practice, and in the Clinton administration, she served as the Deputy General Counsel for the U.S. Department of Health and Human Services and as the Deputy Assistant Attorney General in the Office of Policy Development at the U.S. Department of Justice. She has also served as the trustee on Mass General Hospital and is a former trustee of the Mass Eye and Ear Infirmary. In 2009, she rejoined the board of Planned Parenthood League of Massachusetts, and she has since become the president of that board. Recently, she co-chaired the Boston Bar Association's task on judicial independence. She was a member of the Massachusetts Commission on Judicial Conduct. She also served on the task force that drafted the revised Massachusetts Code of Judicial Conduct. Previously, she was a member of the Supreme Judicial Court's Committee studying gender bias and racial and ethnic bias in the court. She has also published numerous articles, served on numerous boards, and won numerous awards. We are thrilled to welcome Professor Landers to the program.
Well, I'm very pleased to be here with one of the my former excellent students in constitutional law at Suffolk University Law School. So it's really a pleasure to have this conversation with you again.
Yeah, I mean, I feel like this is just a conversation we've been having for 3 years now, and I'm thrilled that even since I've graduated, we get to keep doing it. And so, I am personally very pleased to be able to speak with you and continue talking about this stuff. But also, as I said to you and Ricky, I think you are perfect to do this, to help our listeners understand some of these more complicated cases that are coming up. But before we get into the specific cases, I highlighted the parts of your bio where you've worked extensively on like judicial codes of conduct and judicial ethics. And obviously what's been in the news during the recess of the Supreme Court has been these ethics investigations and this question of whether or not the Supreme Court should be bound by some sort of judicial code of ethics. So as someone that's worked extensively in your career in this area, what are your thoughts on that?
Well, I think it's actually quite shameful that the court has not adopted a binding code of ethics to apply to itself. I mean, every other judge in the country, Article 3 judge, administrative judges, state court judges have a binding code of judicial conduct to which they have to adhere. And, it just sort of defies logic that the Supreme Court should not subject itself to the same rules. I was encouraged this week that Justice Barrett joined, the call for adopting a code, although she did say in the context that all of the justices adhere to the highest standards of ethics, and that obviously is demonstrably untrue. So regardless of, what you think of the politics of the situation, just even on the mere disclosure obligation alone that applies now, some of them are not doing it. So, and then the last thing I'll say, and that if you have other questions, that's great. But is that that the Chief Justice Roberts and Justice Alito, some of them have suggested that it would be improper and unconstitutional for Congress to require them to adhere to a code. And that just can't possibly be true. I mean, the financial disclosure requirements are a feature of statute, right? And they've agreed that they have to adhere to those. So I just don't understand this argument. They're not telling them how to decide cases.
Sure. And so what do you think the holdout is? Like, why hasn't this happened yet? And I mean, obviously, like the cynical part of you would be like Justice Thomas and Justice Alito don't want to adhere to a code of conduct. But it just seems, particularly, Ricky and I have talked about this a lot, where some of these decisions have been so controversial, which has eroded some trust in the Supreme Court, which I don't think the justices should care about personally. Like I don't think that's their job to care about like what the majority think of their decisions. But then when you pair the controversy over the decisions with all of the controversy about the ethics, it just seems logical to me that they would want to reinforce like that part. So what, from your point of view, what's the pushback on this?
Well, I mean, I think two things. I think there are probably some, holdouts, who just don't want to have to change. I mean, I think the reason they haven't been disclosing these because they know these things they've been doing look bad. And so by any stretch, I mean, Abe Fortas, back in the Johnson administration had to resign for taking far less in the way of, financial, gifts, quote unquote, from his friends. So they know it looks bad, and that's why they haven't disclosed. And then second, I think that it's about power. Right. They like to have, they kind of sit at the pinnacle of the judicial process in the country, co-equal, among the other two branches of government. And, the notion that someone else could actually circumscribe their behaviors, I don't know, probably feels somewhat antithetical to them.
Okay. Yeah, that makes sense. Also, before we hop into the cases, now that this court is obviously still relatively new with Justice Brown Jackson sitting for her first term, and still Justice Coney Barrett and Justices Kavanaugh and Gorsuch, still relatively new members of the court. So what are you looking at just like big picture wise for this term of the Supreme Court?
Well, I think, on some of the cases that aren't that don't have a, sort of popular political valence. I think that, that it's not always possible to predict what the alignments will be on the votes in some of these cases. I mean, the obvious, example of that is Justice Gorsuch's opinion in Bostock, right? I mean, that's almost become like a caricature of it, but to illustrate the point. But I do think that and in some of the statutory cases, the decisions can be 9-0, right? And so I think that even though the tone of some of the opinions seems really quite antagonistic and argumentative, I do think that they still are trying to work together, to reach decisions that are reasonable. The one concern I have is the seeming disregard for longstanding precedents, and I think some of the issues that we'll talk about today raise this issue as well. I mean, if the Securities Exchange Act, which has been on the books since 1934, has these profound constitutional flaws, I mean, this we can't rely on anything about the structure of the way things have been if that's the case. So I think that is a bit concerning, and some of them don't seem to have a lot of respect for these institutional arrangements.
I think that's completely fair to say. All right, so let's get into some of these cases. So we're going to start with a pair of cases that I think are quite interesting and quite of this time, where the First Amendment social media cases, they're O'Connor v. Ratliff and Garnier and Linke versus Freed. Both of them in their own way are dealing with public officials who have blocked constituents on social media. And I'm glad the Supreme Court has taken this up, because it's just a mess right now in lower courts. No one really knows how to handle this because this is very new. And so I'm very curious. I don't even know personally how I feel these cases should come out. So I'm curious what you're looking for, and what maybe if you have any personal opinions on these sorts of issues.
Right. So the first thing I should say is the First Amendment isn't actually my strong suit in constitutional law. So I will use that as a caveat. So the court actually had a case earlier involving President Trump when he was president, who actually did the same thing. He obviously famously was, using Twitter to communicate with the American public, and then tried to block journalists and others with whom he disagreed from his Twitter account. And the lower courts actually sided with sided with the people who had been blocked. That they did not side with President Trump on that. And so I think that in these cases, for public officials, if they use their personal accounts to conduct public business, as opposed to exclusively for campaign purposes or something like that, then I think that they really are using them for governmental functions, and they shouldn't be allowed to exclude people from them. I mean, that's just my personal view. Obviously sometimes, the line drawing perhaps could get a little complicated, but I really think that that's what has to happen, because you can't have it both ways. Oh, it's my private account, but I'm going to communicate with the public this way. I just don't think you can have it both ways. I don't know. What's your reaction to that, Brandon?
Do you have any sense where the court's going to come out on these?
I don't know. I mean, I really don't know. They were very circumspect when they had the Trump case, and then it was dismissed as moot because, Trump was no longer the president. So I think but I think they know that they have to decide it in some way. Yeah. And I think the other thing that's coming down the pike, I think actually the Biden administration has asked them to take a look at that injunction against the government for, attempting to jawbone some of the social media companies on issues of public concern. And I think I'm not totally, the government has always, talked to journalists and media and said, hey, don't publish that secret location of our military establishment. Please don't do it, or you can do it in 2 weeks when it no longer is, of importance, the location or something like that. I mean, they've always done that. So this idea that somehow suddenly this is, completely out of the realm of, acceptable action just seems to be, I don't know, not really, very appropriate. So anyway, so I guess the point is, coming back to those cases about the public officials, like I said, I just don't think you can have it both ways. I think, if you're going to use it for public business, even if it's not, paid for by the government and maintained and supported by the government, or the government didn't say to you, you have to use your personal Twitter account to do these things. I think, these are all the arguments that have been thrown up against, saying that it's government action. I think you just have to look at, actually functionally what people are doing with these accounts and then make a decision on that basis.
So I'm admittedly the least of all experts in this small group, but one of the things I was curious about is that it doesn't seem, or it seems that the blocking, whether it was Trump or the school board officials, is a way to prevent other people from kind of attacking them on their own page. I'm curious how I guess the ones bringing the suit here are impacted in a way that it doesn't prevent them from being on the platforms. It probably doesn't prevent them from getting information from these sources, even if it doesn't come directly from that page. It's probably, if it's public information, it's going to be somewhere else. What are they really losing besides kind of the ability to be like there with the first person sort of posts?
That's a really good question, but I don't think the First Amendment regulation has ever rested on, well, you can get it somewhere else, so you can't, we can kick you off here, or you can speak on another platform, right? So you can't do it here. And so, I mean, I guess the answer I would say is that these public officials, they can have the government account, and everybody gets to participate equally on that. And if they want to have a personal account, then don't do government stuff on it. I mean, I would just draw that line. And it's sort of, and I don't think public officials, I mean, I think public officials are used to having to observe those lines, right? They don't use the government car, to go on the family vacation, right? So I think this is kind of a, an iteration of that concept. But I think that's a good question.
Yeah, I'm very curious to hear the arguments, but I think that's really well said, Professor Landers. It makes a lot of sense to me. So we do have another Second Amendment case, another one that I think is fairly interesting. So the issue here is many, if not most states, have laws that prohibit people who are subject to domestic violence restraining orders from possessing firearms. And this happened, I believe, in Oklahoma, where a man who was under a domestic violence restraining order was convicted of possessing a firearm. And originally, the court had held like that was totally okay. But given the court's opinion in the New York versus Bruin case back in June of 2022, they looked back at it and said, actually, given the reasoning the court laid out in that Bruin case, I don't think that laws preventing domestic abusers from having guns is actually constitutional. And so I think this is going to be another fascinating case for this particular court. Of obviously, I think on its face, most people would just be like, logically, people who are under domestic violence prevention orders shouldn't own guns. But on like the other hand is, and this is kind of the same argument why you would say like convicted felons shouldn't own guns. Like, are we depriving people of constitutional rights unjustly? So very curious your thoughts on this, Professor Landers.
Yeah, so this sort of harkens back to your question at the outset. You asked about, what kinds of things should we be looking for this term? And, both in Bruin in 2022 and in the Dobbs case, the abortion case in 2022, the court really heavily laid into the majority this historical analysis of these rights.
Mm-hmm.
And I think the Rami case, and I'm not sure I'm pronouncing that correctly, is really going to test, the extent to which they're willing to adhere to that concept as a way to define rights. Because you can say a lot of things about abortion, you can say a lot of things about, guns generally, or, weapons, firearms generally. But one thing you can definitely say is that the situation of women and other people who are not white males in a household has dramatically changed, right, since the founding. And there was a history and tradition of husbands being able to discipline their wives and to control every aspect of their existence, which is the bread and butter of the domestic violence abuser, is to control the people who are subject to their abuse. And so the court is going to just, it cannot, because of what you just said in the setup to this discussion, I don't see how they can totally lay in to that history and tradition test when so much has changed. And that it just seems, and I was just looking at some statistics that since 2018, there's been this really quite substantial increase in the numbers of murders using firearms by in domestic violence situations. So and that was my objection to the Bruin case too, because the court said, oh, all that stuff about gun violence is totally irrelevant to this analysis. I mean, that just seems to be just not, using common sense. And so I just think they're going to have to confront the limitations of that history and tradition test in this case.
I totally agree they're going to have to confront it, but it seems implausible to me that these justices didn't consider this when they were writing Bruin, right? They had to know that once they laid out this history and tradition test, that they were going to get these sorts of challenges. So I can't imagine they didn't see it coming. And that's why I'm so fascinated with how they're going to wrestle with it.
Yeah, I mean, I think it really will be very interesting. So the one thought I have on that is that I wasn't able to find the specific language this morning when I was thinking about these things, but part of the Heller and McDonald cases rested on, the Second Amendment protects the right of the law-abiding citizen to have a firearm for protection, right? And so one argument would be here is that, obviously this person who is subject to a domestic violence restraining order is not your law-abiding citizen, and therefore, the carve-outs for public safety, sensitive locations, all of that might apply to say, yes, these constraints are okay.
I could see that.
Yeah. The other thing I would say about this is that when Justice Barrett was on the Seventh Circuit, there was a case involving the rule about felons that you alluded to, and the felony that the person had committed in that case, I don't know the name of the case, but was some kind of financial fraud crime or something like that. And she said, well, this isn't the kind of crime to which this rule of barring gun ownership should apply. But then, my response to that is Skinner v. Oklahoma, right? Where that was involved, that Oklahoma statute that allowed sterilization of felons, except for the white collar criminals. So I sort of, I'm not sure that is, it seems somewhat logical, but it could be, the subject of a lot of discriminatory decisions.
A really good point.
I think you alluded to this sort of in the beginning of your response, and something that's troubled me about this case and Dobbs in a similar way is sort of the lack of appreciation for like what are the immediate impacts of a ruling in this direction, right? Like their societal impacts. Brennan always reminds me that the courts aren't supposed to be sort of thinking about the societal impacts, and that's the job of the legislator. But obviously we know when something has a constitutional sort of right ascribe to it, it's a very difficult legislative process to fix. So when you think, or when you evaluate sort of how these decisions go, how much does that go into your thinking on it? Like, well, we know what's going to happen, and the justices should be more, or should weigh that more heavily than strictly the technicalities of the law.
So I think that's a very good question. So I think Justice Breyer was kind of, when he was on the court, he was kind of the ultimate pragmatist, right? You know, what is this law, trying to do? And should we give the legislature, some runway, right, to address what everyone agrees is a very bad societal problem? And so that was, I think that really informed a lot of the way he decided cases. And so I would say that it really, some of it comes down to who decides, right, about what is the proper thing for government to be doing in some of these situations. Should the court, actually give some running room to the legislative bodies to address these current issues? Or is the court just going to be there saying, no, we have these bright lines, and even though a lot of things may have changed, you can't do anything more than you could have done in 1789. And so, that was in the minds of the framers in 1789. So I think that's really, I think that's just, that's really the question, who decides in some of these situations.
Really good question. I want to move on to the racial gerrymandering case. This is Alexander v. South Carolina State Conference of the NAACP. And in this case, a lower court threw out a congressional gerrymander because they said that it was based on race, that they had moved these Black voters around in order to dilute the power of their vote. The Republican legislature in South Carolina countered in saying it wasn't based on race, it was actually just based on politics. We wanted to ensure that this district was for Republicans. And Supreme Court precedent has said that you can gerrymander based on race, but you can gerrymander based on politics, essentially. So I'm curious, this is one of those, to me, this seems like very proxy almost either way. Like, no matter who's doing the gerrymander, you can say, oh, it's because traditionally race and political affiliation have been so aligned, you can just mask racial gerrymanders by saying that it's a political gerrymander. So, as always, Professor Landers, curious on your thoughts.
No, I mean, I agree with you. I think your setup really, illustrates the issues quite well. And I actually think in some ways it's the same kind of issue that was presented in the Students for Fair Admission case, right? So, on the one hand, the court is saying, oh, anti-discrimination is so important, but you really can't think about the racial composition of anything when you're making admission decisions, because that would be discriminatory. So, and I think they've kind of boxed themselves in a little bit here with that earlier case, the Wisconsin case, I think it was, about how the court's going to take its hands off the political gerrymandering issues, which I kind of think was a mistake too. And I think they had, at that time, they had an opportunity to do kind of a bipartisan thing, because there was a North Carolina case where the Democrats had essentially done the same thing, and they could have said, hey, look, guys, play fair. Everybody needs to play fair, and they didn't do that. And so now they have this problem, and so I think it's going to be, and maybe give us some hints about the future of some of these, college admissions or workplace, DE&I challenges that are coming down the pike. They're going to give us some insight, because if you can't, because of this, convergence of race with other sort of non-racial factors. So, for example, there's a case in the Fourth Circuit involving that Thomas Jefferson High School, which is the, kind of one of these premier elite public high schools in Virginia. And, the high school changed its admission criteria and are relying on things like, admitting, a certain percentage of students from every middle school in the district, factoring in income, all these things that in the past the court has said have been okay. And the result of reliance on that is that it changed the racial composition of the entering class of the school. And so the people, the Asian American students who previously had a lot of advantages because, some of them went to preferred high schools and that sort of thing, are challenging this, saying, we have fewer people now. We have, reduced representation in the class. And so that's discrimination against us. So anyway, my point is that, some of these factors like income, zip code where people live because of, racial segregation in housing and all these sorts of things make some of these factors actually not neutral. And maybe, I don't know, maybe that's the same thing for, political affiliation too, in some contexts.
Right. And I think this case is particularly interesting in light of the court's decision in Allen v. Milligan in the Alabama Congressional the Voting Rights Act from last term that surprisingly came out 5-4 to retain I think it was Section 2 of the Voting Rights Act. And so this obviously isn't the same issue, but I'm curious if it breaks down along similar lines.
Yeah, no, I think that's right, because I do think, even though it's true that, the first thing on their minds probably shouldn't be how is the public going to react to these things. If you kind of look at the history of what the court has done over time, it's fairly well tracked with, majority political opinion most of the time. And so, because they can't get either too out ahead of people or stay too far behind, because then people just say, forget it, I'm not going to listen to what they're saying. Yeah.
And I think Justice Roberts in particular seems to be, at least on the conservative side, the one that cares the most about it, which makes sense as being the chief.
Right. I think he does care a great deal about that.
Right. And that almost, he couches this stuff well, even with like the Obama healthcare stuff in like legal opinions. But even last term, it seemed like he was like, I know we're getting rid of affirmative action. Maybe we should leave voting rights.
Right. No, exactly. And then the other one is, even in Dobbs, right? He wrote the concurrence saying, hey, look, just uphold this statute. Don't throw this whole line of jurisprudence out the window. By doing that, we can uphold the statute without, upsetting all of this law. So,
yeah. I mean, his opinion, I think, makes a lot of logical sense. Read in that, and he was just like, I am just not as morally certain as my colleagues on either side seem to be. And I was like, well, that seems fair.
Yeah, exactly.
All right. So Professor Landers humbly said that she wasn't a First Amendment expert, but where she really is an expert is in administrative law. And I would say that even though the First, Second, 14th Amendment cases are maybe more interesting generally, if I had to define what this term seems to be about, it seems to be about administrative law. And two cases that are similar in a lot of ways are the Securities and Exchange Commission, the SEC, versus Jarkissi.
Jarkissi.
And the Consumer and Financial Protection Bureau versus the Community Financial Services Association of America, CFPB. So as Professor Landers said earlier, the Securities and Exchange Commission, the SEC, was put in place post the Great Depression. I think you said 1934, to kind of try to prevent what had just happened in the Great Depression. And very similarly, the Consumer Financial Protection Bureau was put in place in 2012, largely at the direction of Senator Warren, in response to a lot of what happened in the Great Recession. So these are kind of government-created, congressionally created administrative agencies designed to try to prevent some of like the worst of what we've seen in our financial system. There are challenges to both of these systems, arguing that our funding mechanisms are unconstitutional. And obviously,
CFPB case, right? Yeah.
Right. But obviously, like and this is what some of the justices were asking, because this case was just argued a week ago. And this is what some of the justices were asking, like, if you say that this is unconstitutional, like, we're going to have a serious problem with a lot of administrative agencies here. And what are we going to do with all of the rulings that have happened with the CFPB in the last decade, not even getting into like the SEC, like how does that go forward? So I'm fascinated to see how these come out. Professor, what are you thinking about these cases?
Yeah, so I think the CFPB, so first of all, I will say about both of these cases, so you're a litigant and you get in the crosshairs, or you're representing a group of litigants like the the organization of lenders, the community lenders, which I'm not quite sure they're community lenders, or community representatives, but you get in the crosshairs of these administrative agencies. And so, obviously, Jarchese, if you read about the activities of his company, it's not a pretty picture, right? And so then you start looking for, you can't win on the facts of your case because you've clearly violated all these laws that make a lot of good sense.
Right.
So then you start looking around for what else can I do to get out from under this? And so then, happily for them, there are a lot of, legal academics and others who have been promoting these kind of, we have to have these limitations on the administrative state. It's gotten out of control. We have to go back to the good old days where it was just courts and, the Congress and the president and not all of these agencies, right? So I think that's the first thing, is that you just start looking around for, theories that might help you avoid legal liability in these situations. Second, I was reading, some summaries of the Solicitor General's argument in the CFPB case. And, there are a lot of agencies that operate on this basis that's outside the, typical annual appropriations process. So, the FDA is one of those agencies, right? Because Congress made this big point of trying to shift a lot of burden to the pharmaceutical and device industries for, the costs of the regulatory oversight. The healthcare fraud and abuse prosecutions, many, all these, forfeiture, asset forfeiture thing, provisions, and fines, portions of which go to fund future law enforcement activities. I mean, there are just myriad examples of this because, Congress recognized that, they wanted to have like this continuous ability for the government to engage in these activities and not have it be so totally tied to the annual appropriations process. So I think in some ways, if they decide, I think it would be a really radical decision for them to decide that this structure is wrong. Then you would have to ask, oh, well, is the financing of the Federal Reserve inappropriate? Because that's a user fee system. And, there are a lot of people in the banking industry who'd say that'd be great if we got rid of the Federal Reserve, right? But you can't really go back in time anymore because the Federal Reserve is kind of integral to the stability of the financial markets globally, not just in the United States. So, taking a radical position on this would be, I think, really quite destabilizing in a lot of ways. But assuming they did that, they decided they want to stay within their, little bright lines on these things and say, you can't do that. Congress has to appropriate the money every year. So then the question becomes, what is the remedy? And a few years ago, this comes up all the time, especially in the appointments clause cases, which we'll get to when we get to Jarchese, right? Which is, what should be the remedy? And, the catastrophic remedy would be, oh, everything the agency has ever done is therefore void because, the structure was, unconstitutional. The court has never done that. Okay. What the court has done has said, okay, this party, who had the initiative to challenge this, they get the relief. But now Congress and the agency have an opportunity to fix whatever the constitutional defect it is. But we're not going to throw out everything the agency has ever done. There's this sort of principle of regularity that, a presumption of regularity that the court adheres to, and that would sort of insulate all the prior decisions from, any kind of legal challenge.
Right, and that would make it certainly easier if this court decided that they wanted to get rid of it. It wouldn't be quite as
Right.
devastating as I think the Solicitor General kind of tried to paint the picture as.
Right. But then in Jarchese, so Jarchese has three claims, right? So one of his claims is that, having this administrative adjudication system violates the Seventh Amendment because, he essentially committed common law fraud, even though he violated all these statutes that kind of codified that common law fraud. And therefore, it's a violation of his Seventh Amendment right to a civil jury trial. His second is that the delegation of the choice to the agency to either pursue an administrative enforcement action or to take the person to federal court is it doesn't have a sufficient limiting principle, so that that's an unconstitutional delegation by Congress. And then the third thing is that that the administrative law judges who decide these conduct these administrative hearings, they're because they are appointed and are cannot be removed except for cause when they, in theory, respond to the Securities and Exchange Commissioners or the Merit Systems Protection Board, which is the disciplinary body, which both of the members of which cannot be removed except for cause. There's this argument that, and the court has said in another case that these double layers of 4-clause removal provisions are unconstitutional. So the argument is therefore that's unconstitutional. So what do I think about that? So I think this is where this is going to be a very practical thing, right? Because there are, just take, another agency that has a lot of administrative adjudications conducted by administrative judges. You have the Social Security Administration, right? Hundreds of thousands of cases, right? Every year, right? Then you have, the immigration system. Now, they are not ALJs, but nevertheless, thousands of cases. And then you get to the SEC, which also, quite a number of cases, probably not as massive as those other two agencies. The Supreme Court is probably not going to render a decision, which is going to send all those matters into the federal district courts. The courts would be just overwhelmed. This is, these administrative agencies are actually, creating some efficiencies, although, I would be the first to say administrative processes are not necessarily efficient. And that you just can't have the federal courts deciding all these cases. It's just not practical.
No,
So
that makes a lot.
yeah.
I think one thing you said earlier was how the court does, even though that they say that they don't, does seem to kind of move in line with public perception. And what's interesting to me about these cases together is that they're very anti-administrative state, anti what you would call kind of like big government, anti-deep state. But like we're seeing a lot of that rhetoric, or we have seen that in the last 5-10 years in particular, on like the Republican side of like the state is just too big. And obviously President Trump has championed this, like the deep state. And it's just interesting to me. I don't know if you thought about that at all, how it seems now, like not only hearing it politically, we're also seeming to see it legally.
Yeah, no, and I mean that's what I was trying to allude to, that some scholars have taken up this this call to action. And I don't know. I just think it's so first of all, I have two thoughts about it. One is that I think in the modern world, if you look at any functioning, and arguably our democracy isn't functioning too well right at this moment in time, but if you look at any sort of reasonably functioning democracy, there's a lot of big government, right? Just because the world is complex, you have to give benefits to people. You have to decide if they deserve the benefits. You have to give them the right to challenge if they think that they were unfairly denied, improperly denied the benefits. And so, that's just one thing. And then all these, regulatory schemes to promote, the financial stability of markets, prevent abusive, corporate practices. I know, workplace safety, all of these things. I mean, I'm sorry, but the history of the private sector doing the right thing always in these areas is just not a good one, right? You need the government, and it's going to be a big government because the activities themselves are massive now, and so you need a government that's capable of responding to that. And even at the size of the federal government we have now, there's a lot of under enforcement of a lot of these regulatory provisions that some people, on the Republican side, the anti-administrative state people don't like. And so I'm not sure that, I think it's a lot of crying wolf, actually, myself. And I mean, in Jarchese, the, like myriad misrepresentations in his business practices. Why should he get away with this, right?
Yeah, no, it's something that Ricky has said repeatedly, where he said, like, you kind of need these structures in place, because when it comes to these, we're talking kind of market-based things, but even we're talking about like natural resources, like the private sector just hasn't had a good history of doing it on their own. So it's a fair point, which I will concede to both of you.
Yeah, no, but on the other hand, and I would say I'm not one of these people that thinks the government's always perfect. I mean, I think we have to continually challenge them. And on the, on that side of the scale, I would point to, like the Flint, Michigan water crisis. That was all government. But again, it was like trying to do things on the cheap. The Jackson, Mississippi water crisis. It's not clear to me today that they have a functioning water system. And it's been, I don't know, a year more. I mean, this is like crazy, right? Now. And so I think that, government is not perfect either. So it's just this, transparency and accountability aspect of things that I think is really important. The other big agency that I neglected to mention, which I would be remiss if I didn't mention as we're coming up on November, is the Veterans Administration, right? I don't think anybody's saying, oh, we should get rid of that, right? And not do veterans benefits or operate the veterans hospitals or anything. No one's saying that, right? So.
Well, yeah, no one's saying that, but what you're saying is that like a particular decision on these lines would put the Veterans Administration in the same bucket potentially as like the SEC or. Yeah.
Right.
Okay. Last case that I wanted to get into was, again, this is another kind of administrative law case where it's Loper Bright Enterprises versus Raimondo. This is the issue here is, for a long time, the Supreme Court has gone with this doctrine called like the Chevron deference. And that comes from a case, Chevron versus National Resources Defense Council, many years ago, I think 1984. And where it said that like, if a statute is ambiguous, we'll let the administrative agency make that decision. And like we'll kind of give the deference to the administrative agency to figure out what Congress was saying on when it's ambiguous. In this case, Congress said that for fisheries, like for fishermen, fisher people, like whatever, when they're going out,
commercial fishing, yes, yeah,
commercial fishing, yeah, when they're going out, they have to allow kind of monitors on board to make sure that there's not overfishing. That's what the statute essentially said. What the administrative agency kind of interpreted was, all right, well, now these commercial fishermen have to pay for these monitors. And the commercial fishermen are saying, like, that's not what the statute says, and like they shouldn't get the deference to decide that. So the question really becomes how much deference, and that's why I think this case pairs a little bit well with the administrative agency cases. Like, how much deference are we going to give these administrative agencies? So it would upend really 40 years of what the court has done. But as you said, the court doesn't really seem to care about that these days.
No. So, and I think that there have been, well, so first of all, I will say that Justices Gorsuch and Kavanaugh were famously inhospitable to the Chevron deference doctrine when they were on the courts of appeals. Now they're going to have to, decide, what that really means now that they're in a position to actually, say we're going to continue with that or not. The other development that has been coming along has been the court's use of that major questions doctrine that, kind of has been percolating along. I think the first time I really noticed it was in the first case on the constitutionality of the Affordable Care Act, which you mentioned earlier, Brandon, where Chief Justice Roberts, was it that case? No, yeah, it was that case where Chief Justice Roberts was like, oh, Congress, this is like a really big change in the Medicaid program, right? We can't have this. But that was Congress doing it, right? And then we have another one of the challenges to the Affordable Care Act, the King v. Burwell case about the tax subsidies for whether they could be paid to people who bought insurance on federal exchanges as opposed to state exchanges. And the court upheld the subsidies payable on the federal exchanges, but said, it's our decision, and we've decided that that's what Congress really meant, and we can't leave a decision of that magnitude to the agencies involved, right? So when was that case? Like 2015 or something, right? So this has been going on for hints of this kind of emerging trend of the court kind of trying to cabin the range of discretion that the administrative agencies have exercised. So I would say two things about that. One is that it's kind of a red herring to say that the agencies have taken power from Congress. Congress can always take it back if they don't like what the agencies have done. And in fact, they've shown a propensity to do that recently, which, when President Trump took office, they used the Congressional Review Act to rescind 13 different agency regulations, on practically day one of the congressional session. It wasn't day one, but, metaphorically speaking. And then when Biden came to office, they did it again. I mean, the number was much smaller. It was like 3 or 4. But so they're capable, Congress is capable of taking the power back. Now, Congress has, a lot of dysfunctionality, but, if there's a really, kind of searing issue, they're capable of dealing with it. And so it goes back to the earlier point that I made, this question about who decides. And I would say, on the range of decision makers, it's like impossible for Congress to decide, should the Fisher people pay, or should we increase the appropriation to fisheries and wildlife to support the existence of these monitors on the ship, right? And there are a lot of arguments why the government should pay, right? We pay for the meat inspectors, right, to be in the meat packing plants when they're in operation. So maybe this is kind of an analogy there. But they didn't say anything about that. And the agency's like, well, we have to do something. So we're going to make the, fishing industry pay. So the question is, really who, so Congress is just not going to decide all these details of these laws that it passes. It's just not capable of doing it and capable of monitoring, what happens when they decide, should we change, should we tweak it? Should we not tweak it? The agency is capable of doing that. Second, in terms of, if the objection is that the agencies are less politically accountable than Congress, which I agree that that's probably true, they are certainly more politically accountable than the federal judiciary. And so why is it that it's a better idea for the judges to decide, should we have the monitors and who should pay? Or is this stream connected to these other waterways that are part of the navigable waters of the United States? I mean, honestly, it just defies logic that, you have these justices who probably haven't taken a science class, since they were in high school, second guessing the agency. So anyway, so that's what I think about this. But, I think there's, kind of, this seems like a convenient vehicle for upending the Chevron doctrine, because it doesn't have that, or it's not of the order of magnitude of some of those other decisions, like, is it part of the navigable waters or not? It's just like, oh, who pays, right? So it doesn't seem that big. So I think that, if I had to predict, I would say Chevron might be on its last legs here. But and then the other thing is that Justice Jackson is recused from Loper because she was on the DC circuit when Loper was decided. So just this week, the court added the First Circuit case that is the same as the Loper case, which is called Relentless against Department of Commerce. So, yeah.
And I think to your point that they added that because if they're going to upend 40 years of precedent, let's at least have all 9 justices be part of that decision, which I actually greatly appreciate from
Yeah.
the court's perspective.
And I was very puzzled that they only, that they didn't take the, First Circuit, that they didn't sort of reach out and take that when they granted cert on Loper as well, because that just seemed, it was the same issue. So
Right. And I think what will be really interesting for me to watch is that I think there are good conservative arguments for and against this. Like there's the conservative argument to be like, hey, judges shouldn't be deciding, like there's like judicial deference here, like stay in our lane. On the other hand, there's the conservative argument, like the major questions doctrine of, well, Congress is just giving up too much power to this administrative state. So I think I can kind of see a split where Ricky and I have talked in President, as you know, well, like the split often between like the 3 conservative justices and the other 3 conservative justices. I could see that kind of coming in play to this case as well. But as you alluded to, that splits often changes because Kavanaugh and Gorsuch might be together. All right. We'll see how this all plays out. But is there anything else that you are looking at besides those cases that we discussed?
Well, yeah, there's one more, which is kind of in a way a little bit of a sleeper, which is the Atchison Hotels against Lawfer case, which is the one about whether a tester, for to test, whether an entity is complying with the in this case the Americans with Disabilities Act requirements, or any civil rights law, basically, could have standing to challenge, non-compliance if the tester is merely testing and has no intention of, actually using the facility. And so, and I think that, the problem there is, and the person, the Lawfer person was somebody who, has like brought like, I don't know, 600 lawsuits or something like that, because she just sits on the internet and kind of, finds, whether, this little inn somewhere has the disclosure about are they accessible or not to people with various disabilities. So, this is one of those bad facts could make bad law kind of cases. Yeah. But on the other hand, Suffolk University has a huge housing testing clinic, right? Housing discrimination testing clinic. And that, that's how you catch people who have no intention of complying with the laws they don't like. And so I think this is a sleeper one that could have big implications if the court, decides in favor of the hotel.
Yeah, that's definitely a case that I had flagged too, but I'm wondering if they're even going to get there with if it's moot or not. But
yeah, exactly. No, that's exactly right. And then, then we won't even say anything about the lawyer who was bringing all these cases on her behalf, who has now, fallen onto all kinds of disrepute. But anyway, and then, I think those are I don't know, the major cases. I mean, I'm sure that there are some on the criminal side of the docket that, will be significant, but I'm certainly not a total expert on those. So.
And then one other thing you had highlighted for me was whether or not the court decides to take the mifepristone cases.
Oh, yeah. Yeah, no.
So they have.
Yeah, I mean, they're going to have to, because the court has, overturned, a major decision of a major federal agency. And I think that, regardless of what, how people feel about abortion or whatever, I think the stakes are like incredibly high on that one, because the, that there is a problem when the entire pharmaceutical and medical device industries have come down on the side of the government in a case, because they're like, okay, we just cannot have this, where, a judge says after 20 years of safe use of a product, oh no, you can't do it anymore. We invest billions of dollars in developing these products. You just cannot do that. And so, yeah, it'll be interesting to see. And it's not, again, I'm not saying the FDA is perfect, because obviously they're not, right? And in fact, there are all these articles recently in the paper about how, what is it, red dye number 2, right, is banned in cosmetics, but can still be used in food. And it's and the FDA has a very dysfunctional food regulatory section, and I think the current commissioner is really trying to get on top of it. So I would agree that they're not perfect, but it's certainly better than me making some decision about, oh, should that product be on the market? I don't know.
All right, so we'll definitely keep an eye to see if the Supreme Court grants cert to hear those cases. But we hope this was informative for everyone. It certainly was for Ricky and I. And so, Professor Landers, we greatly appreciate your time. I know personally like how busy you are and how many things you take on. So the fact that you were able to give us so much of your time and expertise we really appreciate it.
Well, no, I really appreciate the invitation. And I'm so excited that the two of you are doing this. I think it's an incredible service. And, actually, when you're, when you're, ready, when you've done all your production and everything, if you'd send me a link, and I will see if I can get the Suffolk PR people to put it out on social media. So I'm happy to do that.
We appreciate it. We're always looking for promotion. So that would be good. We'll do.
No, and I'm happy to come back anytime to discuss things as they develop, if it feels useful to you. So,
well, first of all, be careful what you offer. But second of all, yeah, I hope that what I would love to, if we can come back at the end of the, in sometime in July and be like, all right, what happened with all of these cases? I think that'd be really useful to kind of, this is the preview, and then let's review it
I think that'd be really great. And Ricky, what's your last name before we go?
It's Gaucheroy. It's gonna be a tough one to spell.
Well, try me. I'm gonna write it
down. It's Ghoshroy, but I can have Brendan send it over too.
No, I got it. Okay, excellent. Really great. All right.
Very nice meeting.
All right.
Nice talking with both of you. All right. Have a good weekend. Bye-bye.
Well, I really can't stress enough how fun that was for me. I love Professor Landers, and she's just so smart. And the fact that she gave us so much of her time and insight into some of these cases, continue to feel very lucky. Did you have any thoughts on all of her thoughts?
Yeah, I mean, it was I really appreciate that we do these things on video, because I can sort of watch your gears turn as you're digesting, and honestly, I learned a ton there. I thought it was interesting, or I felt like I had some big theme takeaways, and the one that she really, I think, emphasized that I don't know that I had sort of thought of in terms of like connecting the dots, was this idea of like respecting prior precedent. Obviously, with the Dobbs case, that came up a ton, but she did a really good job of sort of explaining like where this is creeping in other areas, and how it can be very difficult to or just kind of the implications of this sort of new way of doing things that is kind of a departure from how the courts have done things in the past.
Sure. And when we had Professor McDonald on for his episodes, he said the same thing. He was normally like the judges on either side of like the legal spectrum will at least pay like some lip service to precedent and like in stare decisis. And what he said, he was like, this court just doesn't seem to care. And that's, I think, troubling for a lot of legal scholars and lawyers, because the foundation of the legal system is that like you pretty much know what's going to happen because of all of this precedent. And I do think it's a little bit scary for many people when that just gets upended and it becomes you don't know what the next year is going to bring in terms of like legal doctrine. I think obviously the other hand, the Justice Thomas view of the world is, if, and I've said this before, if something is wrong, we should change it. Precedent be damned.
Yeah. And I think that like, right. And we've pointed out previous cases that were, decided in the early 1800s or that were clearly antithetical to what the sort of point of either text in the Constitution or what have you were written, and then it makes sense to overturn them. And I think there are those like big philosophical areas that after some serious thought, like it would make sense to do that. And then there's sort of this broad spectrum of areas where doing that really creates potentially more harm or chaos even than it would. And I mean, I think thinking about sort of the different areas, right? So starting with the Second Amendment case in terms of how that might upend how we traditionally think states can manage gun rights in a way that people still have access to guns, but you're trying to prevent people from, killing other people. Domestic violence was in this specific instance, but really, I think more broadly, which is what the kind of the Bruin case opened up, right? And then all the way to what you had brought up towards the end there, the sort of medication abortion drug that recently by a court was removed from like a list of safe medications, and the implication there, obviously, sort of that drug had wide application and people were using it regularly, but also more broadly, as she said, like the entire pharmaceutical industry got together and was like, this is a bad idea. And that's because of you rely on, all of your things are geared towards FDA testing. And as long as you get that, then you're good to go. And now all of a sudden you have to get FDA testing and then potentially like convince a collection of judges somewhere that, okay, beyond our scientific thing, that this is also safe because of whatever. And that creates a whole another mess. And I think it's like a broader, it feels like this is like a broader conversation that's going on. And immediately I thought of the prisoner exchange deal with Iran and how we agreed effectively to unfreeze $6 billion of money that they had in our banks in exchange for these hostages. But then following what happened, we sort of did an about face on that. And just this idea that people really, I don't know, but we've talked about doing a fairness episode before. And I think at some point we have to, but just narrowing the topics is going to be so hard. But just this idea that like, if we know the rules, we can play by them. And whoever breaks the rules, they don't get ahead and right. But when we're also making the rules and then breaking our own rules, then all of a sudden it becomes very, very challenging from business, from individuals, for all across the spectrum. Sorry.
Yeah. I mentioned this already. I do think it's a real reckoning and debate within conservative legal circles, because what have conservative lawyers, they propounded for a long time, this idea that like the judges shouldn't be making the decisions, right? Like we've cried for years of activist courts who have gone beyond what judges should be doing. But now we're kind of seeing when it's like, oh, our activists, like we're getting rid of our, like the things that we don't like. That this is where you have, in my opinion, has always been like, you have to remain consistent. You can't have it one way when the other side's doing it, and then when your side is doing it, being like, well, you did it, so we're going to do it. It's whatever. To tie it all back, it's the same thing we talked about with like the judge's confirmation process or the impeachment processes. Like these things, I'm just asking for some consistency here.
Yeah, no, truly. And it seems apparently it's a lot to ask for.
Yeah, it seems like it these days, but whatever. I think Professor Landers, in addition to breaking down some of these specific cases, I really appreciated how, and I'm glad you picked up on it, like these threads that she was able to draw through all of the cases, kind of where the court and also all of our courts seem to be right now.
Yeah. And then maybe the last thing I'll say was another beautiful through line, this just idea of who decides and where, right? A lot of these cases had to do with whether or not Congress had abdicated too much of their responsibility to decide. And right, that these are the challenges to the Consumer Protection Bureau for one. And I think that this is like an interesting area because we've kind of gone back and forth on this. And honestly, over the years, I think you've worn me down, and I'm kind of more on the idea that it is important for judges to uphold the laws as they're written, because we don't want them going by their personal beliefs. It's kind of the whole point. And yet we live in this era where Congress is I mean, inept is like a nice way, it's like in a nice word. So now what do we do? But I think that and then just sort of this broader notion that the court, while it shouldn't be explicitly adhering to sort of where society wants these things to go, it has to kind of recognize that. But yeah, I think it just makes for like a really interesting era that we live in.
Yeah, and to come back to where we started, I know that this term of the Supreme Court, it doesn't have nearly the attention on it that the previous two terms did, but like this stuff matters. And I'm like kind of hopeful, Ricky. We had talked about this on previous episodes where even though people have been very upset with the court in recent years for a myriad of reasons, the benefit to that, just like the benefit of Trump being in politics, was that like it seemed like all eyes were on the court now, right? It seemed like more people were invested in like reading about and thinking about like the issues at the court. And I hope that we get that for this term too, because like these cases, as you have consistently pointed out, they have real life consequences. They really matter. And just because you don't have the headline of abortion or affirmative action doesn't mean that these really are not going to matter as much or more in some ways.
Yeah, no, totally. I do fear that because they won't get the same type of media attention, that a lot of these decisions will kind of go by the wayside. I feel like I wanted to add my last takeaway. One of the things that she sort of or that you had kind of alluded to in terms of what she was looking forward to, and it seemed like she was sort of saying that like the justices are going to get to know each other more. And that's something that I hadn't really ever considered when thinking about Supreme Court justices. But, as soon as she said that, I was like, yeah, I mean, I bet Scalia and Ginsburg weren't like best friends on day one. It took some time for them to hear each other out, listen to their opinions and their reasoning and stuff like that. And I think that that's probably like an understated way of, or sort of an underappreciated aspect of the court, that as they're sort of together for longer, they start to maybe act more cohesively in a way that allows them to be persuaded by other people's arguments that maybe on day one, they're like, you know what, I'm never going to switch my opinion on XYZ thing, which is kind of what you want, and maybe sort of a benefit that I probably never thought of sort of longer terms serving in courts.
Yeah, it's a really fair point.
All right. Well, yeah. Again, we we continue to get guests that educate us and sort of motivate us to learn more things, but also that are just, like you said earlier, awesome.
Yeah, truly a treat. So I appreciate First Liners, appreciate you, and appreciate everyone listening.
Indeed. Till next time, buddy.
See you.
What I wouldn't give for the hope I used to find in a case of lion's head. Folks of different minds, because even though we did not share the pains we share, that American ideal, friends made over arguments in an early morning buzz. Need an early morning buzz.